The next segment of the program is dealing with expert witnesses. Our moderator is Donna Armstrong, Crown Attorney for what was described to me this morning as the fiefdom of Etobicoke. Donna? And our presenters this morning are Cindy Wasser, Defense Counsel from Toronto, and Pat Ducharme, Defense Counsel from Windsor. Donna?
Thank you, Michelle. We're rushed for time, so I'm not going to do anything other than we've got two tapes that we're going to watch first. The first one, it was prepared by Cindy. And if, Cindy, you could just give us a brief outline of what we can look for in this tape.
All right, I used a true story for this one and embellished a bit to make it the Hollywood version. Something that's coming up frequently now in con applications is the use of a sexual abuse expert who assesses the young complainant in terms of assessing credibility and memory issues as to whether or not she needs to testify or can testify due to trauma or forgetting the incident. This assumes a situation where the Crown is hoping to call the expert to explain why the child can't testify, as well as the mother of the child who will testify as to walking in on the events. The witness is being presented by the Crown as an expert in child memory and sexual abuse, and you can assume that the Crown has already gone through an extensive examination in chief on the clinical background of this expert.
Okay, if we could see the tape, please.
Dr. Smith, have you ever conducted your own research in this area?
No.
Have you ever been published in this area?
No, I have not, but I have read the material.
Your profession is one of behavioral sciences, isn't it?
Well, I'm a clinical psychologist, and I have training in behavioral science, yes.
And would you describe yourself as a scientist?
No, I describe myself as a clinical psychologist.
Well, would you describe yourself as someone then who applies scientific principles?
That's correct.
You do?
I do.
Would one of those principles be objectivity, Doctor?
To the best of my ability, yes.
And is that a universally shared principle of the people in your field?
It's a principle that I hold.
Yes, but is it a universally shared ideal in your field?
It would be a goal to maintain, yes.
To approach new problems with an open mind?
Yes.
And to consider any alternative hypotheses?
Yes.
Right. In this case, you were asked to conduct a forensic interview with the child, right?
Yes.
And that is different from a therapeutic interview, isn't it?
Yes.
In therapy, you are trained to assume your patient is telling the truth, no matter how ridiculous the story, right?
Yes.
And in a forensic interview, you do not make any such assumptions, right?
That's correct.
And you stated in chief, your role here was to determine if this child could describe the events as she had previously, and whether she had a verbal memory of those events that she could share with the court.
That's right.
And to that end, did you run her through any of these standardized psychological tests?
No.
Why not?
Because they do not help with children.
Why is that?
Because children react differently to these tests. They are afraid and uncomfortable.
Well, is there research about this, Doctor?
No, it is my experience.
I see. Well, have you conducted tests yourself on children to make this determination?
Yes.
And do all children respond as you have described?
Yes.
Well, how many children have you done this with then?
3.
3?
Yes.
I see. Have you documented your studies?
It is not a study, and yes, it is documented in the file of each patient.
Patient. So these are therapeutic patients, not forensic clients?
Yes.
Are you planning to present this as a research paper to your colleagues, Doctor?
No.
Why not?
Because it requires more research, and I do not do research.
So this is really a developing theory then, isn't it, Doctor?
Yes.
And one you are unaware of as being shared by your colleagues?
Yes, that's correct.
So one more test, particularly a forensic client, might have aided your developing theory, might not it?
Maybe.
But you chose not to try, right?
I believe I've already said that.
Before you commenced your assessment then of this child, You were given a synopsis of the evidence prepared by the prosecutor, correct?
Yes.
And a copy of the videotaped interview of the child made by the police shortly after the alleged events took place.
Yes, the next day apparently.
Is that what is usually given to you by the prosecution when you are asked to assess witnesses such as this?
Yes, if there is any medical or psychological history, I would want that too, but that didn't exist here.
Did you ask for that then?
Yes. Sorry, I was advised she had diabetes, but I did not have any medical opinion in relation to it.
All right. Would it be helpful to you in assessing the child to have statements by anyone who may have witnessed the events?
Absolutely.
And why is that?
It can provide useful background information for me, which I will use in formulating questions for the interview and in assessing whether there are some details she might remember.
Would you agree that the defendant in such a criminal allegation is a potential witness to the event?
Yes.
You weren't given a copy, though, of the statement made by my client to the police that day, were you?
No, I wasn't aware of it.
Did you ask if there was one?
No.
Why not?
I don't know. I guess I assume if it was relevant, the Crown would have provided me with one.
You just said, though, that all witness statements would be relevant, did you not?
Yes, I guess I should have asked for it.
Did you find the videotaped interview, then, that was provided helpful?
Yes,
And why?
because I could visualize the child as she was interviewed and assess her level of comfort by watching her actual body language as she spoke.
Do you find videotaped interviews are better generally than audio or written interviews?
Yes, for the reasons I just stated.
Would you agree, then, it also provides a guarantee of authenticity to the interview process itself, which would negate in dealing with issues of suggestibility and or fabrication later?
Yes, of course.
You chose not to videotape your interview of the child, didn't you?
Yes, that's right.
Why?
Because it creates a level of discomfort for the child.
Well, had she appeared that uncomfortable to you in the police interview?
A little, yes, she did.
Did you ever ask if she had been videotaped before?
No.
Is it possible, doctor, that she, like any human being, may have been a little uncomfortable being interviewed on video?
Yes, that's possible.
Is it not possible that she, like any other human being, might become more comfortable with successive interviews on video?
That is possible.
But you chose to ignore that possibility.
I did not consider it.
You ignored it.
I said I did not consider it.
Does that mean you ignored it?
Yes, but each time a child is interviewed, it creates a level of discomfort too.
I see. Well, would you agree with me that if she was uncomfortable being interviewed in general, subjecting her to even more interviews in the future might be worse?
Yes, exactly.
Well, did the prosecutor not tell you of the possibility that the child might have to be interviewed by a defense psychologist too?
No.
And of the possibility that the defendant's lawyer may want to interview her?
No.
And you didn't consider those possibilities on your own?
No.
Well, do you agree, doctor, that if your interview had been on video, it might not warrant the need for successive interviews by the defense?
I don't know what you would do.
You don't know what I would do. Well, you didn't ask prior to conducting the interview, did you?
No.
Would a call to the defendant's lawyer, doctor, generally spoil or enhance your level of objectivity?
Okay. Now, just so that we get another example of different styles and different, structures to a cross-examination, Patrick also prepared a tape. And can you give us a brief outline, Patrick, of what we can expect in this tape?
I tried to demonstrate 3 different techniques of challenging an expert that might testify in a trial. The first was that I tried to introduce some new facts to the expert to see whether or not I could move the expert from her original position. The second thing I did is I confronted the expert with a text, with an authority that challenged her methodology. And the third, I went into the area of attempting to create the aura of bias. Ours is not as scripted. I basically told a story to a young lawyer in our firm who had just joined our firm. She's probably hoping that she gets to leave soon after doing this little exercise. But you can see that, like a real expert in a case, she gets a little feisty. She's not terribly enthused about some of the suggestions that are made to her, but at least that's the effort that's made.
Okay, And apparently there's a bit of difficulty with the AV on it.
Yes, I haven't seen this tape, but I understand that her voice is very, very soft, and we used an actual courtroom, and they used the microphones in the courtroom. One of the microphones apparently wasn't working that well, so try to listen as carefully as you can to her voice as well.
Thank you. The tape, please.
Your information came from the mom of this little girl, and the police. Am I right about that?
That's right.
You did not at any time speak to Mr. Jones, the father.
I was advised not to.
Nor did you speak to Annie's older brother, John, who's 13 years of age.
No, I didn't.
Nor did you speak to the grandparents.
No, I didn't.
Yet you were aware of the fact that the grandparents had custody of this little girl for almost 9 months, just a year and a half ago.
I was not given that information.
In any event, whether you had that information, you did not speak to the grandparents at any time, did you?
No, it didn't seem relevant.
Nor did you speak to the aunts or uncles of this child.
It's not necessary in this type of investigation to ask everybody questions.
You determined that the only people that you needed to speak to was the mom and the little girl.
Those are the people I interviewed.
And the picture that you developed in speaking to those two individuals was that this little girl was afraid of her father.
Very much so.
That she refused to even see her father.
That's right.
That she would cling to her mother, looking for both physical and emotional support.
Yes.
I have left before you on the witness stand a note. Could you open that note, please? Would you agree with me that that note appears to be Annie's handwriting?
It may be. It's similar to it, yes.
You've seen Annie's handwriting on a number of occasions, have you not?
Yes.
Do you not agree that that looks like her handwriting?
It's similar, yes.
I understand that that note was written by Annie on October 15, 1996. Have you ever seen that note before?
No, I haven't.
Could you read the contents to the jury, please?
Daddy, I love you and miss you. Please come home.
Now, if I'm right that that note was written by Annie, and it was written in mid-October 1996, that would be inconsistent with the information that you received from Annie's mom, wouldn't it?
I was not given this information by Annie's mom, but it's not inconsistent with my conclusions.
I didn't ask you, doctor, if it was inconsistent with your conclusions. I said it would be inconsistent with the information that you got from this little girl's mom.
I was not told about this note.
The mom had told you that Annie wanted nothing to do with the father.
Yes.
The note seems to suggest that Annie not only wants to be with her father, but she loves her father.
There are possibly many reasons why she wrote this note.
Did you know that Annie had packed a little suitcase with her doll, one of her favorite books, and some clothing on October 25th, 1996, and had attempted to run away to find her dad?
I was not given that information.
Did you know that Annie had made approximately 25 long-distance phone calls to her father somewhere between October 1 and January of 1997?
I wasn't told that either.
So if, contrary to the information that you had, the true picture was a little girl who was actively trying to contact her dad, who was making notes telling her dad she loved him, and who was prepared to run away to find her dad, with all of that information, would you have been able to come to a different conclusion?
Hypothetically, perhaps, but there are many factors that go into an opinion of sexual abuse, and there are many factors which point to abuse. Perhaps those are the factors that point otherwise.
Well, surely if you had had that information, it may have led you to some different conclusion.
Like I said said, there are a number of factors that go into a decision or an opinion of sexual abuse, and my conclusions stay the same.
Your conclusions may stay the same, but you certainly would have taken that information into account.
Of course, I take a lot of information into account.
And with that information, there is the possibility, at least, that you would have come to a different conclusion.
Hypothetically, it's possible.
You are familiar, Dr. Armstrong, with this book that I hold in my hand. American Psychiatric Press, Review of Psychiatry, Volume 10. Are you not?
I'm familiar with it.
If I'm not mistaken, Dr. Armstrong, you have this very book on your bookshelf at your office.
I believe I do, yes.
I couldn't help but note that it was right behind your desk when I went to interview you about a month ago preparing for this trial, this very same book. You recognize it, don't you?
I recognize it, yes.
And the author, Dr. Yates, you are very familiar with his writings in this area of sexual abuse, are you not?
Yes, he's one of the authors I've read.
You believe that Dr. Yates is a well-known, well-respected authority in the area of allegations of sexual abuse, do you not?
Yes, he is.
And you would be particularly familiar, I would assume, with Chapter 15, which deals with false and mistaken allegations of sexual abuse.
I've read it.
I have left a copy of Chapter 15 before you. I'd like you to take that out, please. And I have given a copy to His Honor and a copy to the prosecution. Would you be good enough to turn to page 326 in that chapter? At page 326, about halfway down the page, Dr. Yates outlines 9 different steps in making an effective evaluation of sexual abuse, doesn't he?
Yes, he does.
You are familiar with that 9-step approach, are you not?
Generally speaking, I am.
It's my understanding that in your field, as a person who attempts to evaluate cases of sexual abuse, this is a well-known, well-respected system by which one does the evaluation. Am I right about that?
He is one of, yes.
I have taken the liberty of putting those 9 steps down in somewhat shortened fashion on the board immediately to your right. As I'm asking you questions, Doctor, I'd like you to have reference to that board, and I'm going to ask you whether or not you took any or all of these steps. Number 1, Dr. Yates asks specifically that evaluators gather and review all background information and documents. Does he not?
Yes, he does.
Would it be fair to say that while you looked at a number of documents and you did gather some background information, you did not gather all background information?
I gathered all relevant background information.
Well, surely you would agree that part of the relevant information that you could have gathered would have come from Annie's older brother, wouldn't you?
It's possible.
But you didn't speak to Annie's older brother.
No, I did not.
And some relevant information could have come from Mr. Jones, could it not?
Yes.
But you didn't speak to Mr. Jones.
As I said earlier, I was advised not to.
So in any event, you believe that you gathered enough relevant background information so that you could say yes to the number 1 step here.
Yes, I am.
All right, so write yes next to number 1 then, Doctor. Number 2 says that you should interview all persons involved with the child. You did not do that, did you, Doctor? Would you be good enough to write no next to number 2? Number 3 says that you should videotape your assessment sessions with the child. You did not do that, did you, Doctor?
In my experience, that's not conducive to a free and open exchange.
The reason that Dr. Yates suggests that the assessment session should be videotaped is that anyone who wants to look at them later can determine for themselves what the reaction of the child was to your questions. Am I right?
It would enable lay people to observe the session.
Lay people like the 12 jurors that are watching this evidence presently. Would you put a no next to number 3, please? Number 4 says that you should have 10 sessions with the child to make an objective evaluation. You had 7 sessions. Am I right there?
They were very extensive, involved sessions.
All right. So even though it's only 7, they were extensive and involved. Put a yes next to number 4. Number 5 says that you should provide the child that you're assessing with information about your role and the possible consequences of your evaluation. You definitely did not do that, did you, Doctor?
No, again, that's not part of my experience as being conducive to free exchange.
But Dr. Yates would suggest that's fair to the child because you let the child know what the consequences of whatever the child says are, doesn't he?
I don't agree with Dr. Yates, but certainly that's one of his factors.
Well, you may disagree with Dr. Yates, but would you be good enough to put a no next to number 5? Number 6 is that you are to request all prior videotaped interviews. In this case, we've heard there were 3 of those at the Windsor Police Station. You did not view any of those, did you, Doctor?
I was not informed of any videotaped interviews.
You didn't request whether or not, to find out whether or not there were any videotaped interviews, did you?
I don't recall. I probably didn't.
Put a no next to number 6, if you would, please. Number 7 says that all involved adults should be put through an assessment and a psychological test battery. You didn't do that, did you, Doctor?
I did not conduct those interviews, but they may have been done by others.
And if they were done by others, you never did receive any such report from anyone else, did you, Doctor?
No, I didn't.
Put a no next to number 7, please. Number 8 is that you are to observe the child with each parent. You definitely didn't do that, did you?
No, for the reasons I've already stated.
Dr. Yates would suggest it's important that you see the child interact with her father so that you could assess that. But you had no such opportunity, did you?
No, I didn't.
Nor did you make any effort to have such an opportunity, did you?
I was advised not to speak with Mr. Jones.
And who advised you not to do that, Doctor?
The Crown.
Put a no next to number 8, would you please? And number 9 says you are to note the degree of distress when the child is describing the sexual happening. You did do that somewhat extensively, didn't you?
Yes.
Put a yes next to number 9. So my review of the yeses and nos, Doctor, is that in 3 of the 9 steps suggested, you actually did what Dr. Yates would suggest.
Yes.
Would it be safe to conclude that while you hold Dr. Yates's opinion in high regard, your evaluation is less detailed than what he recommends?
Less detailed, but still as complete, I would suggest.
You receive referrals from the Children's Aid Society, don't you, Doctor?
As do many in my profession.
As a matter of fact, this very case came to you on a referral from the Children's Aid Society.
It was.
And Children's Aid then pays you for doing your evaluation.
Certainly.
And then if you prepare a report that says you believe there may be some evidence of abuse, you know that your report routinely goes to the police service.
It does.
And very often then from the police to the prosecutor's office.
If the police feel it's warranted, yes.
And if there's a prosecution in relation to the matter that you've given an opinion on, you are generally hired as a witness for the prosecution.
Oftentimes, yes.
And that's exactly what's happened here, isn't it?
Yes.
In addition to that, sometimes there are civil cases that come out of such an evaluation, such as a divorce, custody, an accounting of profits if there's a family business, and you are sometimes retained on that as well, aren't you?
Again, almost everyone that I know in my profession is given business the same way.
And as a matter of fact, in this particular case, you've been hired by the attorneys for Mrs. Jones in a civil case of that type, have you not?
Yes, I have.
So you have been hired and paid by the Children's Aid Society, hired and getting paid today by the prosecutor, hired and about to be paid by the lawyers for Mrs. Jones.
Yes, but I guess I just don't agree with what you're insinuating, Mr. Ducharme.
Is it not true that you have never, in the hundreds of cases that you've testified on, you have never once testified for a defendant? You've always only ever been asked by the prosecution. Isn't that true?
Yes.
Thank you very much, Your Honor. Those are all the questions I have.
Pat created my fantasy case.
Yeah, exactly. Okay, if we could just sort of go through some, Cindy, if you could address what you do to prepare for a cross-examination of a Crown expert in this particular area.
Certainly. As you would for the cross-examination of almost any witness in any case, the first step is gather your case law so that with respect to the experts, you know what the parameters are of their evidence, what's admissible and what will be clearly inadmissible. And if you're seeking to disqualify the evidence, the expert and the evidence, you may want to prepare your cross-examination on the voir dire to elicit clearly inadmissible evidence so that the trier of fact will say this is unreliable, this is inadmissible based on the case law. So you have to know your case law in advance. Then you certainly want to understand the report that you've been provided. So you may want to speak to your own expert at that point and go through it with them, get some ideas of where you want to go in cross-examination. You want to understand the area, of course, so you want to read up in this field. And to read up in this field, you have to go to a library, get on the internet, get on email, ask your colleagues if they have similar cases, if they know of similar cases. If you hear that there's one coming up, get into the courtroom, watch someone with some experience doing it, make notes, speak to your colleagues, get transcripts of other cases involving this type of expert evidence, read articles, just get as much information as you can. And certainly one of the most important things I think I just said was speak to your own expert in advance.
Okay, just in light of your comment in terms of reading the case law, it would seem apparent that the cross-examination that you did with, for your example, came from the Olshamp case. Is that fair to say?
I think it's very similar. It actually comes from a real case that I give credit to Frank Addario for. Obviously, we only had 10 minutes on this video. And transcripts are hard to find because you generally only have your expert at trial. Frank was privileged enough to have an expert called at a prelim, so there was a transcript generated. And I'd say that it was pretty much drafted along the lines of Olskamp in trying to challenge the expert on her level of objectivity in not having the proper information, similar to Pat's as well. We did a little bit of an overlap in that area.
Okay. Now, also, Pat, in your preparation, I guess you attend at the expert's office.
I try to as much as possible. I mean, that's not a phony example. There are experts who are good enough to give you the material upon which they rely to give their opinions. And you know, not always in this area. This is such a sensitive area. You'll find some of the experts in this area want nothing to do with you and won't speak to you beforehand. But most good experts, and even some in this area, will be happy to speak to you, give you articles, give you the materials they look to as authoritative, and you should take advantage of that if you can.
In knowing your expert, how do you decide whether or not to challenge the expert that the Crown's calling in terms of their qualifications to testify?
I would say generally with experts, my opinion is that most experts get qualified. Generally, if their qualifications are weak, it goes to the question of weight. This is probably the one area of our law where it may bear some fruit to challenge the expert in terms of qualifications, because as you know and was mentioned by an earlier panel, the cases go every which way, and there are many judges kind of predisposed not to let this type of opinion evidence in, that it's really not scientific at all. Very often it's based on more their personal opinion and their personal observations in their own businesses rather than anything that's generally accepted across the field. So this is an area where you'd want to know everything about the person's qualifications, and you would especially want to know what it is they base their opinion on, because a challenge here to their qualifications could be successful.
And do you know, can you give us some ideas, Cindy, about some effective ways that you've used to challenge someone's qualifications?
Sure.
In addition to what you did
right.
in the tape.
Assuming you are going to go after the qualifications of the expert, you do it very thoroughly. Start right back with their educational background and go through all the courses they took, because you'll be surprised to find that in their background of sociology or psychology, there may be very few courses that were devoted to this particular field, because it's a new field. Then go through the research that they've conducted. You'll probably find that most of them have not, because most of them are clinical psychologists. Go through the cases they list on their CV in which they've been qualified to give expert evidence, and you might find that there are 5 or 6 cases listed, and maybe only one of them, or none of them, revolved around this particular issue they're being qualified for in this case. So what looks like a really good CV, you find out is padded. I had one case where the expert had, under materials, I have access to all these journals that were listed. Well, access was a key word to me, and I said, well, have you read these? Well, I have access to them, and that went on for a little bit. Turned out he hadn't read any of them. Access meant he had the internet. Well, so do I, and I'm not an expert. So be particular in going over that CV, go through their educational background, find out if they have any background in statistics. Most of them do not. And you can really tear the CV apart doing it thoroughly that way. Go through their publications, anything they've read.
Suppose the Crown has brought forward someone that you feel is really qualified, and is there any way that you can turn that, use that expert to your advantage?
Okay, can you hear that? I don't think we should treat experts in this field as any different than really any other witness. I mean, part of our preparation is to know everything we can possibly know about the expert and what they're going to say. And with the beauty of disclosure today, where we get disclosure, we get reports, we get information, we get virtually everything that we need to be prepared to deal with the expert.
How do you plan then, given that you know what your expert is going to say, how do you plan and give structure to your cross-examination?
I'm a firm believer that in trial work you have to have an overall plan, and every little piece of the trial should fit with the overall plan. So first of all, you have to know your story. If you know your story well, then you want to know what aspects that expert may be able to give to you that will help your plan. So the first rule of cross-examination would be to try to get from the expert that which helps you. It's always best to get the good stuff first before you start challenging or taking them on, because they might be more reluctant to give you something after there's been some aspect of the challenge. Much like this witness said, I don't like what you're insinuating. They, take umbrage at the fact that you're challenging their credentials or their knowledge or their fairness or their lack of bias. Witnesses, like any of them, and especially experts, don't want to hear that. So the setting up the structure, I think, is really done with your overall plan in the case. Get as much as you can good from the witness, and then usually, we all know, we don't usually destroy experts. We whittle away. We undermine the value of their opinion. They don't usually walk off the stand in a puddle like we wish they would. They maintain their position generally, and they sound fairly credible, and we wouldn't call them experts unless they were able to do that. They're experts because they know a whole lot about what they're talking about. The best thing I think we can do, get the good stuff and then whittle away at the stuff that's harmful and hope you got a better one.
Okay. What techniques, Cindy, have you used in cross-examining that you find effective?
Well, As I've indicated, you go through the CV, that's one manner. As I tried to show in the 10-minute example, dealing with the objectivity of the expert, you'll have information as to what the expert was given, and try to show that there is other information out there that might very well have affected the outcome of their opinion had they had it. And you build it up. You start off with what is the information you received, how is that information helpful, would you agree that if you had more the more information you had, the better it would be, and then suggest that they have not received all of the information. You want to establish the bias of the expert by, as an example of what Pat did, that they're a hired gun for the Crown, or in a civil case, if you're so lucky as to have your Crown's expert who is personally involved in the civil case. You might want to go into then the content of the material. Issues such as delayed disclosure, incremental disclosure, recovered memory, the substantial issues that the expert will be testifying to, and issues of memory in general. By attacking the papers, the foundation upon which the expert has made this opinion, the research that they've conducted, the knowledge they have, and show them with other research you have and your own experts' assistance how the materials they've relied on are no longer reliable themselves.
Pat, do you have some absolute no-nos in terms of what you should never do with a Crown's expert?
Well, again, I don't think experts are really any different than any other witness. I think when you're cross-examining, the ultimate issue in cross-examination is, do you maintain control of the witness, or does the witness control you? It's just that there's a greater danger in you being controlled by the witness when they're an expert, because you're on their turf. You're talking to someone who's very knowledgeable about an area, so it requires even more diligence on our part as cross-examining counsel to control the witness. So how do you do that? You ask very pointed, very directed, leading questions, and don't let that witness get away on you.
Okay, and Pat, you've prepared a paper actually called The Art and Plan of Cross-Examination, and that was done by you in September of '98. I've had the pleasure of reading this paper, and actually it provides a lot of really good sort of do's and don'ts, and sort of gives you a great structure to a cross-examination of any witness. So it's a good source of information, and I certainly would recommend it to you.
I would be happy, I might say, to provide that paper to anyone who is interested in having it. I presented it here about 3.5 weeks ago on a program that dealt with cross-examination generally, as opposed to the specifics of this cross-examination.
Now, I have to ask this because, well, I just have to ask it. What about reciprocal disclosure of expert reports to Crown attorneys?
I, just a little while ago, did a trial in the state of Ohio. I conducted the whole trial, and there they have reciprocal disclosure on everything. And believe me, as a defense lawyer, it's a nightmare. But in terms of dealing with experts particularly, this is probably one area where I would err on the side of going opposite to what most of us who are defense lawyers think. I think there's a certain aura or feeling about the fairness of the presentation of your expert witness that you can enhance greatly by providing the other side with your report, or at least the gist of what your witness is going to say and the background of your witness. If you don't do that, you run into the inevitable problem that the other side says, you know, I've just gotten this report today, or I've just found out what this witness says by the witness saying it in the witness stand. I'm going to need some time to consult with my expert, and I really need an adjournment. You look like a schmuck. You look like you didn't kind of anticipate this and do what you could to avoid the delay in the trial. I think this is one area where defense lawyers just have to lighten up a little bit about reverse disclosure and think seriously about advancing our stuff. If you've got an expert that's good and knows the opinion, you're not really giving up much. Your expert will hang in there with the opinion no matter what the other side knows in advance.
Cindy, do you agree with that?
I generally take the view that I don't disclose my expert. But if I have the type of case where I want my expert in the courtroom during the evidence of the Crown's expert, it will be obviously disclosed to the Crown. The other times where it may be an issue where I am disclosing my expert is if I want my expert to call the Crown's expert and discuss his view that he intends to testify to later in the trial, so that when I'm cross-examining the Crown's expert, I can put it to that expert that his or her colleagues disagree, and use that as a technique as well in cross-examination. But if I don't have to deal with those issues, I won't disclose the existence of my expert until I have to.
And do you think then, Cindy, it's fair that the Crown ask for an adjournment?
No. They will, and I've had judges who say no, and I've had judges who said you have the afternoon, so they have the afternoon. The tactic is the jury's not going to know why there's a delay. They're just going to assume it's because the Crown's not ready, and they don't get to hear that the reason why the Crown's not ready is because the defense doesn't disclose. They just think the Crown's not ready.
Oh, I think there might be a way the Crown could get that in.
Not fairly.
If you're very creative, I think there's definitely a way that the Crowns can use that to their advantage in the way that Patrick suggested, in the sense of in the manner in which you cross-examine that expert witness, that would, I think, necessarily, because of not being prepared, would have to be very thorough, very plodding, very time-consuming, in the sense of, gee, I don't understand this, because, I wish I'd had some time to really research this, but given the fact that I just sort of got it, Mr. Smith, Dr. Smith, could you help me with this? Because I really am struggling with trying to understand it. It's sort of called the Columbo approach to...
I don't mind if the Crown in my case looks that bad, because I'm not sure the jury's really going to pick up on the nuance that there's no obligation to disclose and the Crown didn't know. They might very well just think the Crown didn't do the work.
One of the things that I'd like to add about Cindy's comment earlier about having your own expert in the courtroom, it's been my experience over the years that when you can have a very qualified expert sit beside you, that alone oftentimes alters the testimony of the expert on the other side dramatically. How many of you who have had this experience have seen an expert testify at a preliminary, and then when you have your hotshot sitting next to you listening to the testimony, somehow that testimony is not nearly as powerful at trial, while another of that witness's colleagues is sitting there listening to every word and taking notes. Tactically speaking, it's a great advantage, if your client can afford it, to have that expert there throughout.
And I certainly agree from the Crown's perspective as well, Patrick, that it's well worth the money spent on if you have a defense expert being called, in terms of, my client couldn't have done this because he's not a pedophile. That kind of thing is normally what the defense would be calling an expert on in this area, at least.
The only thing is, Donna, you're talking about our money, and I'm talking about my client's money.
Yeah, there is a difference.
I had to say that.
Yeah, really, if you have the money, have the expert.
But it is certainly to the Crown's advantage as well to have an expert there, to keep, it certainly keeps everyone more in line and keeps them from going out a bit further than they would otherwise. Just in terms of the case law in this area, I think we need to sort of address that. Obviously, you sort of start with Mohan to determine should you be having an expert in this? Are you going to be able to call expert evidence? Is it admissible? And that is the area that the voir dire will be determining. In this area, Patrick, do you find that mostly Crowns are allowed to call experts? And what are the times when you object to that?
It's really difficult. It seems to be decided on a case-by-case basis. Again, as one of the earlier panelists suggested, some judges seem to have a propensity to find this evidence relevant and helpful. especially when it just focuses on understanding some kind of peculiar behavior as opposed to getting close to the line of oath helping a witness. But it's at least worthy of challenge in most cases because it's decided on a case-by-case basis, and there seem to be an equal number of judges who will say, I don't really see how this can help. Justice Hill has a couple of recent decisions that did not permit the use of experts in this area that are really helpful because as Justice Hill always does, he kind of goes through all of the authorities, and if you're looking for arguments against the use of such a witness, he's probably thought of it, ferreted it out, and said it better than any of us are going to say it, so you can just kind of mouth his words in your application.
Yeah. Two of Justice Hill's decisions I really recommend to you because, as Patrick's indicated, they just sort of lay it all out there. The Queen and C.G., that's April 1997, and it is reported now in 8 CR 5th at page 21. Now, in a more recent one of Justice Hill's decisions is the Queen and BL, which is June of 98, and you'll find that on Quick Law. So those are both. The Olskamp case that we referred to earlier is reported. That's Justice, or as she was then in terms of being Justice of the General Division, Chiron, and that's a December 94 decision reported at 95 CCC 3rd. And the other cases that I think that you need are really important for you to look at in this area are the Queen and McIntosh and McCarthy. That's a July 1997 decision of the Ontario Court of Appeal, and it's reported at 117 CCC 3rd. And the more recent ones that you really require a look are the Queen and RM, another Ontario Court of Appeal decision on October the 2nd, 1998. That's not reported yet, but it's in Quick Law. And the most recent, the Queen and DD, October 7th, Ontario Court of Appeal decision, that is also on Quick Law. And Paul Lindsay advised me yesterday that it's under consideration in terms of whether they're going to appeal that to the Supreme Court of Canada. So that's up in the air right now. Now, in terms of that last case, Cindy, DD, what do you think that does in terms of the Crown's ability to call an expert in sexual assault trials?
I think we should, as the defense bar, stand up and applaud Andras Schreck, who argued the case in the Court of Appeal. It's a phenomenal decision. 3 justices of the Court of Appeal have indicated that the evidence of a sexual abuse expert, a Dr. Marshall, should not have been admitted at this trial because various reasons. The first was the evidence, which related mostly to late or delayed disclosure of the abuse, was not evidence that was directed to establishing a fact in issue. They talked about misconceptions of behavioral science, and they said basically this was cloaking the Crown's case under an umbrella of an expert opinion. Secondly, they said it failed to meet the test of relevancy. Its probative value was outweighed by its prejudicial effect. They said that given that the evidence was that delayed disclosure may be seen in cases of abuse and it may not indicate abuse, they found that it had very little probative value. The Court of Appeal also said that it was a blatant attempt to bolster the credibility of the Crown witness, the main Crown witness who's the complainant, and that is perfectly acceptable in that case where the complainant had explained why she took time to disclose, that is the evidence that the jury should try and assess on the issues of credibility. They're the triers of fact, and an expert explaining delayed disclosure is only bolstering credibility. And that's been an area that the courts have indicated in the past, including RM, which is hard to understand here, as an area that is acceptable, because just a week earlier, the Court of Appeal released RM and KM dealing with Dr. Armstrong's evidence, and said that Dr. Armstrong had testified about delayed or incremental disclosure, recantation, and other behavior said to be consistent with child sex abuse, and then said that most of this was not challenged, and the court took the position that this type of evidence made, the defense strategy made sense because our courts have accepted the need for the admissibility of the kind of expert evidence given by the doctor. So either they're saying in DD a week later, we're wrong, it shouldn't be, or else this part doesn't make sense to me, but I think it's a really critical case, DD.
But I don't, in terms of calling experts from the Crown's perspective, I think we need to be careful in terms of calling experts, especially now since we have been given a lot more latitude in terms of developing the narrative. I think we're able to get into a lot of more background and put a context to a situation than we ever used to. Would you agree with that, Patrick?
Yeah, I would agree with that. And what's difficult to reconcile in all of these cases, even judges who exclude evidence go on to say, generally speaking, that other evidence, that doesn't mean other evidence of similar type might not be let in another case. They're fact specific. They say, well, in this particular case, we're talking about delayed disclosure to one person, but there wasn't delayed disclosure to another. So what happens is the state of the law is a mess, quite frankly. It's not clear, and you have to look at your facts and see whether or not you can somehow torture your case into one of the arguments where either it excluded if you're on the side of the defense or included if you're on the side of the Crown.
And clearly it's left open somewhat in Casey, or Justice Hill's decision, where he outlines in the areas where expert evidence is still vital. So there still are areas, so there will be lots of opportunities for you to sharpen your cross-examination skills of experts. Okay, our time is up, and thank you very much.
Sorry, do you have the OJ numbers for the quick law cases that are reported?
I do, and I can provide them to you later, okay? Okay.
Okay, Donna, panelists, thank you. Okay, we're going to move directly now into the last portion of the program, which are various issues related to sentencing. I'm going to ask all three of our speakers to come up now. And rather than having a panel presentation, what we're going to do is to hear from each speaker individually on a specific topic related to sentencing. We're going to hear first from Richard Schneider, also known in some circles as Dr. Richard Schneider. Richard is also a clinical psychologist, many of you may know. Richard practices as a defense counsel here in Toronto, and he is going to address the use of psychiatric and psychological assessments in sentencing. Richard?
Thank you very much. As Michelle indicated, I've been asked to talk about the use of psychiatric and psychological assessments in sentencing. So just as for an opener, you should, of course, be aware that there's a difference between psychological and psychiatric assessments, particularly in terms of the statutory authority for obtaining them. Most psychological and psychiatric assessments, of course, are used to determine the issue of either fitness to stand trial or criminal responsibility. But a lot can be done with psychological and psychiatric assessments at the sentencing juncture. The only thing that you should be aware of is that the two mechanisms that are used to obtain psychological or psychiatric assessments, I should say, don't include a provision to obtain psychological assessments. In the criminal code, the general section for obtaining psychiatric assessments is in 672.1 of the criminal code. That's part 20.1 of the criminal code dealing with mental disorder. And in 672.11, they refer to a court having jurisdiction over an accused in respect of an offense may order an assessment of the mental condition of the accused if it has reasonable grounds to believe that such evidence is necessary to determine, and then a number of purposes are enumerated. If you go to the definitions section of assessment, you'll note that it means an assessment by a medical practitioner. A psychologist, of course, is not a medical practitioner. A psychologist is, in Ontario at least, somebody who has a PhD in clinical psychology and then normally 2 years of internship. A psychiatrist is a medical practitioner who's obtained a specialty, much like you would become a dermatologist or an ophthalmologist. A psychiatrist has become a psychiatrist. He's an MD. So there's no, generally speaking, within 672.11, there's no authority to have a court-ordered psychological assessment. The bigger problem with 672.11, of course, is that there's no enumerated head dealing with the sentencing juncture at all. You'll notice that psychiatric assessments can be ordered to determine whether the accused is unfit, whether the accused was criminally responsible at the time the criminal act was committed, whether well, there's an infanticide provision, a provision to determine what the most appropriate disposition would be upon a verdict of either unfit or not criminally responsible. And then there's a section at the end dealing with hospital orders, which at first blush might seem to be appropriate to sentencing, but it only has to go to the issue of whether a hospital order can be ordered for up to 60 days at the beginning of a sentence. The problem with that provision, you might see that as the vehicle to sneak in a court-ordered psychiatric assessment at sentencing, is that the hospital order sections of the code haven't been proclaimed. So far as court-ordered psychiatric assessments are concerned, there is no provision within the criminal code to obtain one. The psychological assessments, similarly, there is no authority to obtain one by way of court order. What has recently come about is the use of the Mental Health Act to fill in the gap in 672.11 of the code. The two most conspicuous gaps, most practitioners agree, would be no ability to order an assessment for sentencing and no ability to order an assessment at the point of judicial interim release or bail considerations. There are two obvious junctures where psychiatric information can be very useful, if not imperative, but deliberately or otherwise, we don't know. Parliament's chosen not to include those as enumerated heads or purposes for which a psychiatric assessment can be ordered. So we've gone to the Mental Health Act and sections 21 and 22 dealing with out or in custody assessments respectively. Those provisions allow a judge who has an accused before him who appears to be suffering from a mental disorder to order an assessment for a period of up to 60 days. The condition precedent there, along with a number of others that I won't bother reading to you, you'll see in in sections 21 and 22 and the sections thereafter. The key one, though, is that you need to, first of all, obtain the consent of the prospective receiving assessing facility. That will give you the opportunity, if you can convince the judge that it's appropriate, to get a psychiatric assessment at the sentencing juncture, while the provisions of the criminal code don't allow for it. So those are the two primary vehicles for obtaining psychiatric assessments. The criminal code is really of no assistance. The Mental Health Act is of some assistance in terms of obtaining court-ordered psychiatric assessments. Again, with respect to the distinction between psychiatric and psychological assessments, the Mental Health Act there again is of no help, because the Mental Health Act indicates that the senior physician shall report in writing to the judge as to the mental condition of the person. So Psychological reports, if you think you need one, and they can be very useful, have to be privately arranged, either by way of private retainer or a disbursement authorization on a legal aid certificate. Psychological and psychiatric reports, particularly at the sentencing juncture, can deal with precisely the same issues, but of course they're prepared by two different professionals. Focus is the same, the orientation is generally slightly different. The psychiatrist is going to take more of a biomedical approach, and the psychologist generally will take more of a psychometric behavioral approach to assessing the accused. So far as tactics are concerned, though, generally it's advisable not to go by way of court-ordered assessment anyway. The problem with court-ordered assessments, of course, is that they come back to the judge and all parties. So, you know, it's much better to contain the report, to obtain the assessment privately, find out what the psychologist or psychiatrist is going to say before you decide whether or not you're going to use it and disclose it to the other side. Because a court-ordered assessment, if you're able to obtain one, could do your client much more harm than good if the report is disastrous. The next thing that you should be aware of is that this psychological report can, of course, go to answer many questions at sentencing. You know, it's not just a character assessment of the accused, but it can be used for a variety of specific purposes. And these are recognized in the case law, but you might use the psychiatric assessment, and we're talking, of course, at the sentencing juncture. There is a conviction, but you can use it to show that, in a way, your client is perhaps more sympathetic or less culpable than the accused who's not suffering from some sort of a mental disorder but who has committed the same offense. So even though mental disorder was not put forth as a defense at trial, or was put forth but was not successful, the court must nevertheless consider any operative mental disorder in imposing sentence, because the sentence must fit not only the offense but the offender. The psychiatric and psychological reports are also used to show that your client, because of the condition he suffers from, will cope less well in prison. And so therefore, any term of imprisonment which is imposed will be more severe for your client, and on that basis should perhaps be attenuated relative to what the otherwise appropriate sentence would be from a strict tariff perspective. It may be that your client will require special accommodations such as segregation, and this again the court should recognize as a more onerous, harsher form of incarceration than for the accused who's going to be serving his time in a general population and will have greater freedoms and be able to avail himself or herself of a wider variety of programs. The other key thing to use the psychiatric or psychological assessment for at the sentencing juncture is to show that a particular mode of treatment or intervention is viable for your particular client. And the court, of course, particularly when mental disorder is involved, are very concerned that the mental disorder be contained so that whatever danger or risk that the accused had that caused him to commit the offense doesn't result in further difficulties. It may be that protection of the public may be achieved through some form of treatment or counseling that might reduce the need for incarceration. In fact, the psychiatric or psychological report might go so far as to show that prolonged incarceration would be detrimental to recovery. And now, of course, with, I think it was Bill C-16, terms can be included in a probation order that will require a specific type of treatment. The other traditional reason that you might want to demonstrate to the court that your client does suffer from a mental disorder, whether contained or not, is that the traditional heads of sentencing may be to a lesser extent appropriate. It's recognized by the courts that general and specific deterrents are not of paramount concern when dealing with a mentally disordered accused. Obviously, like-minded individuals aren't going to benefit from the sentence that's imposed if the accused is mentally disordered. Similarly, if the accused was mentally disordered at the time of the commission of the act, it's not going to be of much specific deterrent effect or utility. The other major reason that you would want to obtain a psychological or psychiatric assessment is to show with the ability now to obtain a conditional sentence, which Paul's going to talk about, that your accused is not dangerous. It may be that the psychiatric or psychological assessment will show that despite the appearance of the index offense, the accused would, and the magic words are, would not endanger the safety of the community, and that therefore, pursuant to section 742.1, you may be in a position to seek a conditional sentence. And there again, as with probation orders, you are able to obtain in a conditional sentence terms that will require the accused to submit to or attend for treatment that again can contain or mitigate any sort of risk that the accused might present to the community. Where to get psychiatric or psychological assessments? Again, you know, the only thing I can recommend in that regard is that you go to somebody who you is referred to you as a specialist in the forensics area, a reputed psychologist or psychiatrist who has experience in court. Shop around, talk to fellow counsel, find out how strong particular witnesses are as witnesses, and generally how they're received. Don't, you know, go to the yellow pages or phone OPA for a recommendation. I would sincerely recommend that you speak to people who've had experience retaining experts in the area. What to tell your expert? And this was certainly mentioned with the earlier panel, and I would just want to amplify it and emphasize the importance of it. Make sure that you give your expert the good, bad, and the ugly. There's nothing to be gained by providing your expert with a selected array of information for him to base his opinion upon, or refer him to a limited number of individuals who you suspect are going to say positive things about your client. Nothing is more brutal than for cross-examining counsel, Crown Counsel, to show that really the opinion is worthless because the information that he's basing his opinion upon is narrow. It hasn't considered, information that the Crown witness has considered. Make sure that your expert has had the benefit of receiving any other conflicting report or conflicting information. Because of course, and this is trite to say, the opinion that you obtain is only as strong as the evidentiary foundation or the factual foundation upon which it's based. So make sure that your expert witness is provided with everything that you can provide him with. And if at the end of the process the assessment turns out to be not particularly helpful, that's fine. But it's better to go that route than to put your witness up and have him demolished during the sentencing hearing. Thank you very much.
Next we're going to hear from Paul McDermott, who is a Crown attorney here in Toronto, and Paul's going to talk about the availability of conditional sentences of imprisonment.
Thank you. I'm going to truncate my comments. There's a paper at tab 5 of the materials, and in the paper there are 37 cases summarized in which conditional sentence was imposed or substituted on appeal, or the Crown's appeal was successful, or the defense request on appeal was unsuccessful. So there's a stage that you can see as the paper goes along, first in favor of conditional sentences, and then situations in which it was not granted. So I'm not going to repeat the facts, and they're easily read. And the difficulty with them, though, is you won't find in them any principles. I think if there's one disadvantage at this stage of the law of conditional sentencing, and that's that there is no body of opinion that lays down principles as to when it's applicable and when it isn't. It's being granted and refused in alarmingly similar factual situations. It's being imposed on an ad hoc basis. I would suggest the law seems to bear out. The one thing that I think you can say as a broad statement is that sexual assault is one of the most prevalent areas in which it is imposed. And this may have appeared to have been an area prior to the advent of conditional sentencing that would surprise people, but it hasn't. And the paper is restricted to courts of appeal. And uniformly across the country, they've approved of conditional sentences in sexual assault cases. So as a broad statement, I think you can say that the field's wide open for the imposition of a sexual assault, a conditional sentence in a sexual assault case. If there is a line in the sand, it may be whether or not there was intercourse. Of the 17 cases that I've included, only where a conditional sentence was substituted on appeal or a Crown appeal was dismissed, there are only 3 that include intercourse. So you won't find this statement actually in any of the judgments or that principle espoused, but I think that you can see from a review of them, if intercourse takes place during the abuse, it's going to be difficult to get a conditional sentence. Not impossible, but more difficult. So as a broad statement, I think you can say that the field is wide open. There are 2 good articles actually in the criminal reports, one at 10 CR 222 by Professor Roberts, a professor of criminology at the University of Ottawa, and at 15 CR 176 by Professor Manson, in which they debate each other, or certainly Professor Manson debates Professor Roberts' view about whether or not a conditional sentence is a break and whether it really is a lenient disposition. And this debate has been raging. It seems a little academic, and I don't mean any disrespect to the various professors, because I think if you're practicing, it's obviously a break. It's a tremendous break, and so and perhaps evidenced by that the defense wants it and the Crown doesn't. So you could take some evidence by the various positions. So but I don't see how that really matters. It's being imposed. There isn't a court in Ontario or in Canada that has disputed Justice Rosenberg's principles that it should be given broad application of the conditional sentence, that it was a parliamentary initiative which the courts are bound to impose when appropriate, and that there's certainly nothing in the sexual assault field that would disentitle the offender to a conditional sentence. And indeed, I think the defense could argue, and the Crown respond with some difficulty, that historical sexual assaults are one of the best fact situations in which to impose conditional sentence, because you don't need a psychiatric report like Richard in many cases, because you can say, I've got 20 years of proof that the man isn't going to reoffend. Now, he's been convicted of this offense, and the conduct is reprehensible, obviously, after the finding of guilt, and it needs denunciation, deterrence, retribution. There are generally all of the aggravating factors that the case law has developed. Yet, the most important principle in the conditional sentencing is on the facts of the case themselves, without any expert evidence before the court, and that is that he is no longer a danger to the community because I've got 20 years of proof of that. Now, a psychiatric evaluation will help, but I think the defense is armed with some evidence there after the finding of guilt that is important. I think another important tactic that needs to be considered is the effect in the appellate courts across the country of the 3 cases that aren't referred to in the paper but are fairly well known, MCA, Shropshire, and McConnell, in which the Supreme Court of Canada repeats and emphasizes the deferential standard of appellate review in sentencing cases, and goes to great length to champion the role of the trial judge as the best person to impose the just and appropriate sentence. And so I think from the defense and the Crown standpoint, if at the sentencing hearing, the more you can encourage the judge to follow the words of these cases in terms of the primacy of the role of the trial judge in the imposition of sentence, the better chance you have as the case goes along to have the sentence upheld or have the Court of Appeal not interfere. There are 2 cases in the paper which SW and McNaughton, they're endorsements, and they're on the sites are there in the OJs on the Quick Law. And they're endorsements only, in which the court says that this is one of the rare cases in which a conditional sentence will be imposed in a sexual assault case. And if I were the prosecuting attorney, I would be borrowing the language of the Court of Appeal and trying to use it. But I think that, again, to take the defense position, I think the defense position hasn't been irrevocably hurt by that or even damaged to any great extent. There's no discussion in either one of these cases of the principles in Wismire. There's no discussion of why sexual assault cases should be rare for the imposition of a conditional sentence. And so I think that those, and the facts in those cases aren't terribly egregious, but there is no discussion in either one of these cases, and I don't think that they could stand long for the proposition that the effect of Wismire and these other cases across the country has been overly dissipated. The discussion of electronic monitoring hasn't really come into you'll see it in some of the cases from out west, but the electronic monitoring aspect of a conditional sentence hasn't really arrived in Ontario. But word is that it's on the nigh, and it is, for the defense, I think, an excellent argument for the imposition of a conditional sentencing in these cases. But as I say, the paper speaks to most of these issues. The issue in the largest sense is the conditional sentences are appropriate in sexual assault cases. There are cases reviewed in the paper in which the Crown has attempted in appellate courts across the country to create a category of offenses or a subcategory within sexual assault in which the court will say a conditional sentence is not appropriate. And the Crown has failed in all of these attempts. The court responds that Parliament didn't say so and the courts aren't going to do it. So I think there's good news there on the sexual assault conditional sentence area for the defense. For the Crown, I think the emphasis should remain on the principles of sentencing as codified by Bill C-41. Each and every one of them seems to be in favor of the Crown in this argument, but the extent to which they've gathered favor in the courts of appeal has been surprisingly bare.
Thank you, Paul. We're going to go a few minutes over, for which I apologize. We've tried to make up as much as we can for the lateness. But Peter Napier has come from Kingston to talk about a topic that is particularly important to those of us who are defense counsel. Once we get our clients into the system, how do we get them out of custody, parole and early release strategies? Peter?
Thank you, Michelle. I suppose I'd begin by just with a disclaimer of sorts, in that parole issues aren't in any way as perhaps intellectually challenging as many of the other issues you heard about today, but indeed they have a very direct and immediate impact upon the client for obvious reasons. And there have been a number of changes since the introduction of the Corrections and Conditional Release Act some years ago. And in my view, it's extremely important to understand the consequences of that act, how it interacts with the sentence imposed, so that you'll be in a position to advise your client. So if you could bear with me, I'll provide you with an overview of it, and perhaps it would be easiest to do so in a manner involving an analogy of a 3-year sentence imposed on January 1, 1998 for historic sexual assault. So that would be the date of the sentence commencement. Now, everything in terms of early release runs from that date. And there are 3 broad types of hearing, or 3 broad types of release issues surrounding the 3-year sentence. The first one is a parole granting process, wherein the applicant goes before the parole board and makes an argument for a parole release. The second type of release is known as statutory release. It used to be referred to as mandatory supervision, a term which you may have heard in the past. It's now called statutory release. And then that arises at the 2/3 point. So to summarize, you have day parole arising on July 1, 98 on the sentence imposed on January 98. Full parole arising on January 1, 99. And finally, the statutory release arising at the 2/3 point of the sentence on January 1, 2000. Now, what do you do with those dates, and what implications do they have for the client? Well, the first broad area, as I indicated, was a parole granting process. And that involves a formal application made by the client to the National Parole Board for a conditional release in advance of the day and full parole eligibility dates. Counsel's role at the hearing, which will be conducted in front of a 2-member panel of the National Parole Board, is filled with a few oddities. The Parole Board is a body, members of which are appointed by Parliament, pursuant to the Corrections and Conditional Release Act, which is the governing legislation, which directs Parliament to appoint members to the board that represent a broad section of the community. So traditional legal safeguards, both procedural and substantive, are often absent at these hearings. And you must be aware of that. I mean, the first time you walk into a parole board hearing, you really maybe wonder what's going on. The parole board adopts very liberal views in terms of what they can ask the client. For example, the board takes the position that they can question the parole applicant on charges that have been stayed or withdrawn, or upon which the client has actually been acquitted. Now, they take this position because there's a Federal Court of Canada decision which says they can ask those questions insofar as it may establish a so-called criminal lifestyle of the parole applicant. The parole board members don't understand that distinction, and in practice, they'll question the client on stayed, withdrawn, or charges upon which there's been a conviction solely to attempt to elicit an incriminatory response from your client. So if you get in front of the board and they ask you those sorts of questions, it certainly is advisable to object to them strenuously and simply advise your client not to answer the question. There's absolutely nothing improper about that. You're not entitled to any cross-examination of any of the reports filed by the parole board or relied upon by the correctional service. So you're in a situation where you get a negative psychiatric report or a negative psychological report. Again, you're stuck with that. And the only way you can call any evidence whatsoever, you're not entitled to call witnesses. You can get evidence in front of the parole board by way of affidavit evidence or in written materials, but that's the extent of it. So that's the parole application process, the day or full parole. And I've set it out in some more detail in the paper which you can refer to. But a word of general caution, because of the nature of the offense for which our hypothetical client has been convicted, there is no doubt that the board is going to approach this case extremely cautiously. So you can have someone who has a historic sexual offense, a lengthy period of bail, a lengthy period of bail pending appeal with no incidents at all. And notwithstanding the board's overall mandate being one of whether or not the person will reoffend, the person stands a very, very good chance of being denied early release on parole because of the nature of the offense and because of the parole board's sensitivity to any type of early release for these type of offenders. So assuming the hypothetical client doesn't make it out on parole, the next issue is statutory release, and that's the 2/3 point. Now, prior to 1986, you could say with absolute certainty that when you get a 3-year sentence, you'll be released after 2 years. Parliament proclaimed Bill C-68 in 1986 and amended that legislation to provide the parole board with an additional detaining power. So now the parole board has the authority to keep your client in for the entirety of the 3-year sentence. And you see that remarkable power, or at least what when the legislation came through, one viewed it as what would be remarkable power. In fact, it's very commonly used power today, and it's extremely commonly used in cases involving a sexual offense. In order for the board to keep an individual in for the entire sentence, that is, past the statutory release date of the 2/3, they must be satisfied that that individual is likely to commit an offense causing death or serious harm. Serious harm is defined as severe psychological harm or serious personal injury. In practice, the parole board is virtually prepared to presume the existence of severe, and I emphasize that because that's what the legislation says, severe psychological harm in the absence of any evidence in the form of victim impact statements and so on. Chances are then that the hypothetical client will be in front of the parole board for a detention hearing. That hearing will be conducted. The role of counsel is very similar to the role in the parole granting hearing, and then the issue is whether or not that person is detained in custody until the warrant expiry date or is released at the 2/3 point. I've included some statistics which, in my view anyway, speak volumes of the present state of the parole board practice. They appear at page 7 under tab 6. And it indicates clearly that the detention process is frequently applied to individuals convicted of a sexual offense. 1989, 1990, shortly after the legislation was introduced, the rate has doubled. In sexual offense cases during 1994-95, 342 offenders got to the 2/3 point, the statutory release date, and almost half of those were referred for detention. Now, the referral is the process by which the correctional service suggests to the parole board that these individuals should be detained. So almost half were referred, and the remarkable factor is that the board received 144, let's call them suggestions from the correctional service that someone be detained. Of the 144 referrals, the board detained 137, or a whopping 95.1% of the cases that came before them. So certainly an individual serving a sentence for a sexual offense, and this really is the bottom line, and it's not a pleasant bottom line, or it's not one I'm enjoying telling you about, but the accurate advice to give a client convicted of a sexual offense and the accurate knowledge to have when making submissions on sentence is that in reality that client stands a very real prospect of serving the entirety of the sentence imposed. And that's what I'll leave you with.
Thank you, Peter, we think. Thank you all for coming out. I apologize again that we started late and that we've run over time. The next program is going to start, I'm told, at 1 o'clock. So then, rather than keep you for a question period, I'm going to invite you to talk to our panelists individually if you'd like, and let you go for lunch. Thank you.